Hey guys, Anthony Bandiero here, attorney, senior legal instructor. Another roadside chat. And our question comes from an officer from Texas. Can a person in police custody provide consent to search without violating Miranda? The answer is yes. Here's why. Miranda only applies for the three conditions. The person is in arrest-like custody, one. Number two, the officer is asking questions which is foreseeable that they would the answers would incriminate the person, right? Two, that right? And number three, we're talking to a known officer. The suspect knows he's talking to a police officer versus an undercover agent. Well, we're missing something here. We have in custody, arrest-like custodies. Actually, back up. I didn't tell you the fact pattern. So let me tell you what. An officer stops a suspicious male in a parking lot who is stumbling all over the place, appearing heavily intoxicated. They meet the criteria for a public intoxication arrest. So the male is placed in handcuffs and in the patrol vehicle. Items were removed from his pockets, right, per his consent and so forth. You know, this is just a public intoxication, almost like we're almost like community caretaking. We're trying to help this person, not to get hit by a car and so forth. The officer then asks for consent to search those items. Now, I understand, and the cop understands too, that this is probably going to be justified under a search incident to arrest. But the officer wants to go beyond this. He did ask this person for consent without reading him Miranda, and he's under arrest in the back of a police car. Is that consent valid? I mean, does the fact that he does not have Miranda invalidate it? And the answer is no, because consent is not something likely to incriminate himself. It's not interrogation. Asking a person, hey, can I search your car? Can I search your backpack? Even though they're under arrest and you have no right to search those things, is not incriminating. It's not interrogation. That's why Miranda is not required. Further, there was a U.S. Supreme Court case on this issue. It's called U.S. versus Watson, like 1976, where the suspect was in the back of a police car in handcuffs under arrest. He had nothing to do with it. He was not arrested from his vehicle. He was arrested from a restaurant. And the police asked for consent to search his vehicle. And he said yes. And based off the totality of circumstances, the court upheld it, even though no Miranda was provided. Now, sometimes giving Miranda will help, just kind of show that he has rights and it's less coercive. But the point is, it's not required. And that is why. All right. Keep the questions coming. I love them. And hopefully you're enjoying this channel too. We're getting more people. This thing is, it's one of those things where you build up an audience and it starts off slow. For every subscriber you work really hard for, but then exponentially it starts building up. People start sharing them and you hit the subscribe button. Okay. Hit the like button. And if you like what I'm doing here, thank you. Right. I appreciate it. All right, guys. See you next time.
When it comes to law enforcement training, we are the gold standard. Visit bluetogold.com or call 888-579-7796 to learn more about our training, books, and free webinars. Also, don't forget to like, subscribe, and share this channel.